You know, a lot of people think that to be a good lawyer, you have to behave like a total jerk. And the problem is that a lot of lawyers think the same thing. For those of you who don't know me, I am Viva Frei, a Montreal litigator turned YouTuber turned accredited mediator, although I haven't had my first mediation file yet, so I guess I'm just accredited, but not yet a mediator. I do these things called vlogs, VLAWGS, where we break down something that's going on in the news or in the legal world in terms that can be understood by lawyers and non-lawyers alike. A video series that I've been doing that people really seem to appreciate is breaking down depositions conducted by lawyers. Because a lot of time what goes on in these depositions is either incomprehensible to anyone who has never sat in or conducted an examination, or so nuanced that anybody without legal training or legal experience might miss the actual key, essential, important, interesting details. I did a breakdown of Lil Wayne's deposition, which I'll link right here. Incidentally, that video was copyright claimed by Warner Brothers TMZ, and I filed a dispute on the basis that the deposition itself is public domain and cannot be the object of copyright. And I say this not to rub it in anybody's face or to gloat. They withdrew their copyright claim, and I was able to monetize that video for the full $91.45. I did a breakdown of Justin Bieber's deposition from years back and Alex Jones's recent deposition. I'll link those at the end of this video, so go watch them if you haven't seen them yet. And I've had two depositions that have been burning the back of my head that I've wanted to deal with because they are so interesting, to say the least. One of them is a perfect example of how an examining attorney should conduct a deposition, and the other is a perfect example of how a defense attorney should not conduct a deposition. Okay, you go and get this idea. Boom! The first deposition we're going to deal with is in the context of the examination of David E. Taylor. He's a minister that was being investigated for misappropriation or misspending of ministry funds. And the second deposition we're going to look at was in the context of a lawsuit called Testmasters versus Blueprint. It was a lawsuit between two LSAT prep courses. Testmaster was seeking an injunction against Blueprint because apparently the Blueprint instructors were former employees from Testmaster and basically stole all the teaching methods that they were using and exploiting in the context of their new business venture, Blueprint, which was competing with their former employer, Testmasters. That is all the context we need for these depositions, so let's just jump into it, shall we?
Alright, so what is this residential center?
Oh, this is a place that the ministry owns. Well, not own, we're in the process of buying that. We don't
So are
own
you
it yet.
renting to buy, or are you...
Yeah, we're leasing to buy.
You have that as an asset of $2,844,500. So do you own it?
I just answered that, didn't I? I said we didn't own it.
Okay,
We're
but
leasing
where
to buy
does
it.
the... I'm sorry?
We're leasing to buy it. Did you? I thought we just said that.
Alright, but
Yeah.
you have listed it as an asset worth $2,844,000.
Oh, that should be more of a liability.
So you can see what the examining attorney is going after here through her line of questioning. It is a very specific, targeted, goal-oriented line of questioning. The examining attorney is seeking to demonstrate that Mr. Taylor has been using ministry funds for his own personal property, personal assets, personal use. And not only are the questions specific and targeted, the examining attorney knows the answers to the questions so that when the answers she gets from the witness don't coincide with the reality, she then knows exactly where to go back to her line of questioning to get the actual facts out of the witness. The answer provided by the witness is to the effect that the residence is not owned by the ministry. An ill-prepared attorney who doesn't necessarily know the file might miss that opportunity to confront the witness with the fact that it is listed as an asset on the financial statements. An asset being something that the ministry owns. And so this is a perfect example of not only asking the right targeted questions, but knowing the answers and knowing how to properly follow up on what might not be a 100% accurate answer.
Alright, so where does the number $2,844,000 come from on your asset and liability?
That's, I guess, the appraisal value of the home or the residential center.
Is it a home?
No, it's a residential center. We use it.
And you see here again, the examining attorney is paying close attention to the answers being given. And when the witness seems to slip up and qualify what was being passed off as a ministry asset as a home, the examining attorney jumps on it to highlight, call it an admission or call it a mistake, depending on whose attorney you are, but she jumps on it. And the important thing to notice is that she doesn't jump on it in an aggressive, in-your-face, oh, did you just lie right here? It's a very calm, non-aggressive, non-confrontational way of putting the contradiction out there. A lot of attorneys think that aggression will get results. This examining attorney is going to show you that aggression doesn't always get results, and more often than not, calculated, calm, cool, non-intimidation from the examining attorney can lead to more fruitful That was the dog that just sneezed like that. Can lead to a more fruitful examination, a more productive examination. Let's keep going.
You're saying it's not something you own, but you have it listed as an asset of $2.8 million.
That's probably a mistake. Like I say, it probably should be a liability.
And here you see the examining attorney is getting the witness to be caught up in a contradictory story. It's not a home, then why is it an asset on the financial statements? Oh, it should probably be a liability on the financial statement. And here's one of those situations where the examining attorney knows that either way the witness is going to have a problem. Because either Mr. Taylor has to admit that the residence is a home, as appears on the financial statements, or now has to go back and correct financial statements that have been issued year over year, which is itself a problem. And one of the cliches of law is that you don't ask a question if you don't know the answer. This would be one of the questions where it doesn't matter because, as we say, either answer is going to get the witness in trouble. It's either a home, as listed on the financial statements, or it's not a home, in which case the financial statements are inaccurate or incorrect. Ow. Let's keep going.
November 29th, 2013, JMMI paid over $6,000 to Louis Vuitton. What would that be for?
A short, concise, targeted question. Clearly framed, just explain it. Explain it. No argumentation, no judgmental formulation of the question, no twisting words, no convoluted phraseology. $6,000 on Louis Vuitton. What would that be for? Answer. Enlighten the court.
This is for clothes concerning my TV.
Where you have to wear Louis Vuitton. What do you mean they're allocated to you? So you used ministry money to buy your wardrobe.
Outfit.
Your
It's allocated more towards ministry apparel.
Does that go into what your income is? Do you show that in your income that you got Louis Vuitton clothing?
No, that's not.
That doesn't show.
And not being a tax lawyer, I'm not going to get into the actual substance of what appears to be the object of this investigation. What percentage of personal expenditures are legitimate tax deductions? What are inappropriate given the nature of the institution? That's not for me to get into now, nor is it the purpose of this video.
But they have to be top-of-the-line expensive ones.
No, they're not top-of-the-line clothes.
Louis Vuitton's not top-of-the-line?
Those not where I get my suits from.
Well, you got something from them spent thousands and thousands.
Well, the belts are more lasting, so that's good.
Come on, you're buying belts for $5,000?
No, I mean multiple belts.
And here it's actually interesting because you can see the only real time in the excerpts we're going to look at where the examining attorney lets a portion of the examination get away from her is when she starts actively arguing with the witness. And it's in this back and forth bickering that she allows the witness to give something of a reasonably understandable justification for the expenditures. There's no comment on the substance of this investigation. All I'm saying is that at this point in the examination, you can see that the bickering back and forth with the witness did not yield the results that were beneficial or that the examining attorney was after.
All right, you testified at your last deposition that JMMI owns 3 vehicles, a BMW, a Mercedes, and a Bentley.
Yes.
Have you driven those cars?
Yes.
A very clear setup. These are your cars? Yes. Have you driven them? Not do you drive them, not are they yours to drive. Have you driven them? Yes or no? Because the answer is only yes or no, with the legal consequences that that answer can entail.
No.
But do you see my point that people that are suffering and giving you whatever their last dime is and donations and drug habits, to have them see you drive around your high-profile guests in a Bentley or Mercedes might be offensive and hurtful even.
It could be offensive if they didn't know my life, but they know my life. It would be offensive to someone like you who's trying to make it bad.
And here's another good example of where when the questions lead to argumentation, it leaves the witness the opportunity to explain his way out of the situation. There are 2 separate issues here. There's the moral issue as to how this pastor is spending ministry money. Then there's the legal aspect of it. And the witness has his answers. Maybe his followers like seeing him drive around a Bentley. I don't know. But right now, as you can see, when the lawyer gets into arguing with the witness, she's arguing the morality of his conduct with him, where all that matters is the legality of his conduct.
There's a series of documents that total almost $50,000 to limo land in 2013 and 14. You have to answer yes.
Yes.
Okay, what was that for?
That was to cut the Mercedes into a limo.
All right, I think we got as much value as we're going to get out of that particular deposition. If you want to watch the entire thing, there's hours of it online, and there are a few summaries or condensed highlights. But now let's just jump right into the how not to conduct a deposition if you are the witness's attorney in the context of an examination, shall we?
Thanks for telling me the questions I should ask, will have your opportunity at the end.
Just shut up and move on with your questions, okay?
All right, so the one thing every attorney has to bear in mind during an examination is who are they trying to impress? And there's only one answer to that question. The answer is the judge, because that is the only person who, at the end of the day, is going to have his or her say on how the dispute is going to be resolved. And when I say that the attorney's objective should be to impress the judge, it's not in a superficial way, it's not in a kiss butt kind of way. It's in the sense that the only person controlling the outcome to the file is going to be the judge if it gets to trial. Or jury if it's a trial by jury, but you know what I mean. So acting like this...
Just shut up and move on with your questions, okay? Just shut up or I'll adjourn this deposition. I'll get you some tissues and you can cry.
in the context of a deposition might impress your client in the context of the deposition. Oh, look how hard and mean and aggressive my lawyer is. He's giving the other lawyer such a hard time. Oh, he must be good. This gets in front of the judge, it's going to come back to haunt you. This goes on in front of the judge, it doesn't go on for very long. And incidentally, how does someone shut up and move on with their questions at the same time?
Just shut up and move on with your questions, okay?
This is another classic oxymoron like Jumbo Ship or Flat Mountain. Okay.
You asked him if he ever spoke with Farsh about anything. He said no. Now you're asking him to tell you what Farsh told him. It is a bullshit question. It is absolutely speculative, no foundation or anything else. Now he's entitled to a fair question. You told him that. So if you're going to sit there and ask unfair questions, I'm going to correct them.
No, not exactly. If a lawyer is going to ask unfair questions, the only thing the other lawyer can do is object and instruct the witness not to answer. They cannot correct the questions because it's not their examination to be conducted in the first place. They don't get to rephrase the examining attorney's questions. A cross-examination is just that. It's a cross-examination. The questions are directed at a hostile witness or the opposing party who necessarily is not there to cooperate and collaborate with the other party's attorney. You don't just ask the question once, you get an answer, oh, okay, I think I'll be on my way now. No.
So I don't waste this guy's time having to come back or go to trial and undo the mess that you're trying to create. Got me?
Are you finished?
Are you finished?
Are you
Do
aware?
you understand the question,
Are
Mr.
you aware
Fisher?
of the local rules
Mr.
with
Foster?
regard to what objections you're allowed to make and what
Do
you're
you
not?
understand the question?
If the lawyer has a problem with the questions, object. If the questions are improperly phrased, a judge adjudicating on the objections will come to that conclusion at the hearing on the debate of the objections. And incidentally, let's open up two parentheses here.
Nothing in this video constitutes legal advice. If you need legal advice, go to a lawyer. This is for entertainment and information purposes only.
Didn't really make any sense. Second parentheses. Once upon a time in Quebec, there were rules for objections. You could object if the question were hypothetical. You could object if the question were asked and answered. You could object if the question was abusive, etc., etc. And the objections would be noted, and they would then be subsequently debated in front of a judge. But what ended up happening was that there were so many objections, there was systematic obstruction in so many examinations, the court system was being overloaded with debate of objections before judges. And as the practice of law evolves, so too does our Code of Civil Procedure, and it was amended to implement new rules to the effect that all questions have to be answered even if there is an objection to them. The objection will be taken under reserve, meaning that the objection will be raised in front of a judge, and at that point the judge will determine if the question is proper or improper. If there's an objection, the question is still to be answered under reserve with very few exceptions, those being professional secrecy, confidentiality, and a couple of other exceptions where the question need not be answered. But in general, by and large, under our new Code of Civil Procedure, as are the new rules of collaboration and not overwhelming the judicial system with unnecessary debates, all questions have to be answered even if there's an objection. Let's keep going here.
Mr. Foster.
Sir, right now this is my witness. I get to ask the questions. You get to make objections only. There are two types of
Call the
objections
bailiff.
you can make. Objections
Call
to
the
form.
bailiff.
Call the bailiff, call the bailiff. Now, let me explain to you what he's saying right here. Typically, the examination would be conducted in the courthouse. And if there were a problem that arose during the examination, the parties could, in theory, go get a judge to adjudicate on that objection on the spot. The reality is that depositions are not always conducted at court. So you can't just go upstairs and get a judge. And even when they're conducted at court, it's not like judges are just sitting around twiddling their thumbs. Judges are busy with other files. So you can't just run upstairs, get a judge, like you're going to your parents to say who's right between two siblings fighting. It just doesn't happen. So what this lawyer is saying right now is, call the bailiff, we'll go in front of a judge right now and have this objection adjudicated, knowing darn well that that's not going to happen. What would happen in reality if the examining attorney wanted to get really frustrated? They'll say, okay, this examination's over. We'll conduct it in front of a judge, and we'll have a judge adjudicate on whether or not the opposing party's lawyer is obstructing or facilitating the examination. But that lawyer knows that nobody's calling a bailiff because nobody's getting in front of a judge, so he's going to get away with it for now. But this is going to get in front of a judge at some point in time. And right now the witness is smirking because he thinks his attorney is doing a good job for him. In reality, the attorney is doing a disservice disservice for his client. Because this examination will either just be reconducted in front of a judge, where the lawyer is not going to get away with any of this type of conduct, or the judge is going to read the transcript, watch the video, and come to very negative conclusions as to the unwillingness of the witness to answer relatively straightforward questions. There are times when the conduct of the attorney reflects poorly on the witness.
Don't ever presume that you get to tell me what to do or when to do it, counsel. Don't you ever presume. He has no dog in this fight, and you're trying to get him to say things that are simply untrue. It's an old trick, Mr. Zohar.
You don't think you're trying to coach the witness right now?
I'm telling him what the question is so he can answer it.
Do you know what speaking objections are?
Don't lecture me, idiot. I'm telling you I'm not gonna let that happen. Okay? You got me? Do we understand each other? Are we connecting here? Because if we're not connecting here, I will try again.
In Quebec, we have a code of ethics that requires attorneys to be courteous with one another. I would imagine that in any jurisdiction, anywhere, there are similar obligations. I'm not sure that this type of discourse is courteous, but maybe it gets better.
Don't give me local rules, don't give me procedures, don't give me professionalism.
Don't give me local rules, don't give me procedure, don't give me professionalism. I'm going to make a shirt that says just that.
Just put a fair question to the witness. And if you're not going to do that, then I am. We understand each other?
If you believe that a question that I ask is not proper, then you get to pose a valid objection. You're not allowed to make speaking objections. You're not allowed to give your
Don't lecture me,
opinions.
puppy. Don't lecture me. I was doing this when you were still chasing cheerleaders. Don't you even think about lecturing me about depositions.
The oldest trick in the book is when an attorney relies on his experience and undermines the youthfulness of the other attorney. How many times as a young attorney I heard that? It's maddening, it doesn't impress anybody, and it actually just makes you look totally insecure, weak, and unsure of yourself.
Do you think that there's anything wrong with adding testmaster students who you met only by virtue of your employment at Testmasters to a prospective client file for your competing company?
Would you read the question back, please?
This might be the only time during this examination I agree with the witness's attorney. That question was convoluted, it was subjective, it was moral, it was, do you not think that there's anything wrong with introducing prospective clients that you met through older?
Do you think that there's anything wrong with adding Testmaster students who you met only by virtue of your employment at Testmasters to a prospective client file for your competing company?
The question was incomprehensible. For the first time, the lawyer puts his hand on the witness quietly, patiently, and says, can you reread the question? Because it's incomprehensible. Let's just see where this goes.
Object to the question is no foundation. It calls for speculation. Seeks a legal conclusion that's argumentative, and I'm instructing the witness not to answer.
Mr. Tatey, do you think that it would be improper for you to copy your employer's course material while you're a Testmasters instructor and use it for a competing business?
Same objections, same instruction.
The witness's lawyer formulates a proper objection without shouting, without calling anybody puppy or names or idiot, without telling anyone to shut up, and sees results. And watch what's going to happen. The lawyer is going to formulate this very same objective over and over and over again for the rest of this examination, basically interfering with any sensible, what's the word I'm looking for? Oh, whatever, basically obstructing with the examination and making it impossible to conduct.
So as we sit here today, you don't know whether or not it's a true statement that as of March 30th, 2005, Blueprint had not yet finished the writing and production of its LSAT course.
Objection, argumentative, and also invades the attorney-client privilege.
Yeah, I don't know how that question could possibly invade attorney-client privilege, but this lawyer will have to justify his conduct to a judge at some point in time when they adjudicate on all of these objections that he's raising.
Do you deny, Mr. Tatey, that as of January 12th of 2005, that Matt Riley was a Blueprint partner?
Objection, same objections, same instruction.
Mr. Curry, this goes to the very heart of the case here, and I'd ask you to reconsider your instruction and allow Mr. Tatey to answer this very simple fundamental question.
Asking the objecting attorney to reconsider, yeah, you're going to reason with this attorney. He's going to really think about his objection and say, yeah, I made a mistake. I should really allow the witness to answer. Let's just hear what he says.
I've reconsidered. The answer is no.
Can you rule out the possibility that Matthew Riley was a Blueprint partner while he was still teaching for Testmasters?
Same objection, same instruction.
Do you deny that Matthew Riley was a Blueprint partner at the same time that he was teaching Testmasters classes?
Same objection, same instruction.
Do you deny that Matt Riley was working on the Blueprint website while he was still teaching classes for test masters?
Objection, it's argumentative, calls for speculation, there's no foundation, instruct the witness not to answer. Objection, calls for speculation, no foundation, it's argumentative, instruct the witness not to answer. Same objection, same instruction. Objection, vague and ambiguous. Objection, argumentative, no foundation, calls for speculation, instruct the witness not to answer. Objection, calls for speculation, no foundation, it's argumentative, instruct them not to answer, it's phrased.
Okay, that's fine. I'm not asking any more questions. I want to make a record here, if I may, Mr. Curry. Your instructions not to answer numerous questions are improper and unfortunate, particularly in light of these new documents that were just discovered. The judges repeatedly suggested that there's a likelihood of having follow-on discovery after e-discovery. I think that it's improper, and I think that you're obstructing our ability to get to the bottom of these critical and highly damaging documents. And I'd like to put you on notice that if you don't allow us to continue to ask questions now or at a subsequent time, that we believe that you will be obstructing our ability to obtain evidence about improper discovery abuses by your client, and that you will be aiding and abetting in those discovery abuses. And I ask you to reconsider.
I'd like to put you on notice. Watch what happens when you put that lawyer on notice.
Take your threats and put them where you don't litter.
I'm not making threats.
Yes, you are.
And in fairness to the witness's attorney, the lawyer is making threats. He's personalizing the debate to the lawyer. Whether or not the lawyer is behaving properly or improperly, you take it in front of a judge. You have the judge decide that. You don't make these personal accusations, personal threats against the other lawyer personally, because like it or hate it, love him or hate him, the other lawyer is just doing his job. Maybe not properly, but the lawyer is just doing their job. And by instructing the witness not to answer on the basis of an objection which may be ill-founded in fact and in law, they are not aiding and abetting. They are not getting personally involved in the file. They are just doing what they think is their job. If you don't like it, take it in front of a judge, and the judge will sanction that attorney. But these types of threats are personal. They personalize the debate, and they are totally unnecessary.
Like your work, Mr. Curry? Sure. Like your work? Sure. Like your work, Mr. Curry?
I think they're being tongue-in-cheek when they say, "I like your work, Mr. Curry," but there you have it. How to conduct an examination as the examining attorney, and how not to conduct the examination as the witness's attorney. If you like this content, be sure to like, share, subscribe, hit the notification bell, leave a thumbs up, drop a comment down in the comment section, and now you know your vlog. Peace out. I screwed up the peace out. Peace out. Boom!